OK, bonjour tout le monde. Bon matin.
Good morning, everybody. Good morning. It's a delight to be here with you as always.
With everybody. I call the meeting to order. This is meeting 115 of the Standing Committee on Procedure and House Affairs. Bienvenue à la 115e réunion du...
Welcome to meeting 115 of the Standing Committee on Procedure and House Affairs.
Reminder, colleagues, that we do have new protocols in place in regards to our audio devices. I think we've been through this enough times now that we know the appropriate step is to place the piece on the sticker when it is not in use, out of respect to the health and safety of our translators as they do their important work. Colleagues, a couple of housekeeping things before I introduce the topic of conversation for today. We do currently have bells planned at about 10:45, so we will have to decide at that point in time what we want to do as a committee. We are scheduled to be here for 3 hours this morning and into the early afternoon, so I will be calling a few health breaks as we have done in the past to allow witnesses and staff and others the opportunity to move around a little bit. So, colleagues, we are here today to begin our study on a review of the members of the House of Commons workplace harassment and violence prevention policy. We have a number of familiar faces with us here as witnesses today, so I would like to welcome Eric Jantz, Clerk of the House of Commons, Michel Bédard, Law Clerk and Parliamentary Counsel, Carolyn Oh, I had it, Carolyn. I had it. We talked about it. Evangelides? Did I get it? Close enough. Evangelides, that's it. Evangelides. You said let it roll off the tongue, and I didn't. There it is. Evangelides. Thank you, Mr. Calkins, who is the Chief Human Resources Officer. We have Patrick McDonald, who is the Sergeant at Arms and Corporate Security Officer, as well as Jeffrey Leblanc, the Deputy Clerk of Procedure. You will have up to 10 minutes, witnesses, as a group for an opening statement, after which we will proceed to questions from committee members. I do understand before we begin that Ms. Romanado wanted to speak to something briefly. Ms. Romanado, if that's still the case, the floor is yours.
Thank you, Mr. Chair. I just wanted to make sure that I know members received a briefing note. Thank you so much from the analyst. Today's study that we are starting is on the harassment policy and not on the sexual harassment policy. So we just want to make sure it's very clear that what the scope of the study is. Thank you. Merci beaucoup.
Analyst, did you want to speak to this, or are we okay? Colleagues, we're good on that? Excellent. Okay. With that, Mr. Jantz, the floor is yours, and the 10-minute opening remark period begins.
Very good. Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. I'd like to begin by thanking you for inviting us to appear before your committee today. I understand that you're interested in knowing about and improving the regimes currently in place for preventing and addressing situations of harassment and violence in the workplace, where members of Parliament, their staff, House administration employees, and members of the public and of other parliamentary institutions work together.
That members of Parliament, employees of members or of the House administration, as well as members of the public who participate in the day-to-day activities of the institution, are protected from violence and harassment. This is certainly an objective that we all share as senior House officials, and we trust that our testimony today will assist the committee in its important deliberations. We will begin by providing a jurisdictional overview of the harassment and violence policies currently in place for employees of the House of Commons administration and of members, along with governing legislation and regulations. We will also overview the Code of Conduct for members of the House of Commons sexual harassment. We will outline the roles that the Board of Internal Economy and the Procedure and House Affairs Committee have played in their development. Thereafter, we will present the members of the House of Commons harassment and violence prevention policy in its current form, as well as the Code of Conduct for members of the House of Commons sexual harassment. We will then provide the committee with recent developments and address any questions that members may have. I will now invite our law clerk to provide a jurisdictional overview.
Merci, Eric. Il existe plusieurs politiques et codes.
There are various policies and codes that are aimed at preventing and dealing with harassment and violence in the workplace at the House of Commons. The motion adopted by the committee for this study mentions one, namely the members of the House of Commons Workplace Harassment and Violence Prevention Policy, which was adopted by the Board of Internal Economy. There's a similar harassment policy adopted by the Clerk of the House of Commons for the administration, and parliamentary partners are also legally required to adopt such policies. In addition, as members of this committee know, there's the Code of Conduct for members of the House of Commons, sexual harassment between members, which comes within the purview of the committee pursuant to Standing Order 108-3A9. The members of the House of Commons Workplace Harassment and Violence Prevention Policy was, as I mentioned, adopted by the Board of Internal Economy under its general authority over administrative matters involving the House and members. The policy is also part of the condition of employment and supports members in their role as employers of their staff. The policy applying to members and their staff was adopted by the Board of Internal Economy and replaced by a new policy, the one currently in place, following new regulations, specifically the Workplace Harassment and Violence Prevention Regulations. This came after the Canada Labour Code was reformed to include harassment as a health and safety matter and was made applicable to parliamentary employers, including members of Parliament. The policy was recently reviewed by the board, but no substantial changes were made.
Conduct for members of the House of Commons, sexual harassment between members. It resulted from a study of this committee following an order of reference from the House, instructing the committee to examine policy options for addressing complaints of harassment between members and make recommendation for a code of conduct for the prevention and resolution of harassment in the workplace. As its title indicates, the Code of Conduct ultimately recommended to and adopted by the House is limited to sexual harassment. Following the 2018 review of the Code of Conduct sexual harassment, it was contemplated that PROC was to undertake a study on non-sexual harassment, but it did not begin such a study before the dissolution of the 42nd Parliament. The Code of Conduct sexual harassment constitutes an expression of and is rooted in the parliamentary privilege of the House of Commons to discipline its members, similar to the Conflict of Interest codes for members of the House of Commons. Both codes are appended to the standing orders. Going back to the members of the House of Commons Workplace Harassment and Violence Prevention Policy, it does not fall, as I said, within the mandate of this committee. That said, it's not the first time that the board and PROC are both interested in the same matter. For example, in the 42nd Parliament, the issue of maternity and parental leave was studied by the board. However, as it did not have jurisdiction over this subject, the board referred the matter to this committee, which examined the subject and made recommendations to the House that were later adopted as the regulation respecting the non-attendance of members by reason of maternity or care for a newborn or newly adopted child. Inspired by this example, PROC could, should it determine that changes to the policy are required, write to the board to suggest that there are amendments to the policy. I note that the Standing Order 108-3A1 contemplates such a collaboration between the BOI and the PROC, in that PROC can, as part of its mandate, review and report to the Speaker and the board on matters related to the administration of the House of Commons. To conclude, whether harassment prevention or resolution proposal comes within the direction of the board or the House acting on the recommendation of PROC will depend on the circumstances. Harassment prevention as a health and safety matter in the workplace will generally come within the purview of the board as an employment matter. In contrast, regulating member-to-member conduct will be a matter for the PROC and the House to decide. I will now invite the CHRO to provide additional context respecting the content of these policy and the code.
So as outlined by the clerk, I'll begin by providing the committee with a brief overview of the harassment and violence policy, creation and development, its current state, and a distinction from the Code of Conduct for members of the House of Commons sexual harassment between members. La politique de prévention du harcèlement.
The members of the House of Commons Harassment and Violence Prevention Policy was approved by the board on January 28, 2021, to replace the one approved by the House of Commons on December the 9th, 2014. The new policy is intended to help members of Parliament meet, as employers, the new legislative requirements of the Canada Labour Code that came into effect on January the 1st, 2021, as well as to foster a healthy, respectful, and harassment and violence-free work environment. The policy was recently updated and then approved by the Board on February 15th, 2024. For your information, in accordance with the policy's requirements, I'll present to the Board on May 30th next the annual report on the members of the House of Commons Harassment and Violence Prevention Policy for the 2023-2024 fiscal year.
Prevention policy governs the behaviors of members as employers. However, it does not encompass member-to-member interaction. As mentioned by the law clerk, the House adopted a motion instructing the Standing Committee on Procedure and House Affairs to explore policy option for handling complaints of harassment among members on November 27, 2014. A subcommittee at that point of PROC was created to A, examine policy options for addressing complaints of harassment between members of the House of Commons, B, propose a code of conduct to prevent and address workplace harassment with a clear definition of harassment. C, make recommendation concerning a fair, impartial, and confidential process, including options for the role of an independent third party for resolving complaints made under the code. And finally, D, to make recommendation concerning training and education initiatives to ensure compliance with the code. On June 9th, 2015, the Code of Conduct for members of the House of Commons Sexual Harassment was adopted by the House following a study and report presented to APROC. En 2018, le Code a été...
In 2018, the Code was revised. On May 31st, 2018, the Standing Committee on Procedure and House Affairs adopted the revised draft report entitled Code of Conduct for Members of the House of Commons, Sexual Harassment Between Members. The revised version of the code was then introduced and adopted in the House of Commons on June the 20th, 2018. Improvements include aligning the Code of Conduct with the members of the House of Commons Harassment and Violence Prevention Policy at the time, adopting a limitation period, and implementing an investigation process.
Members to confidentially raise concern of sexual harassment by other members to the Chief Human Resources Officer or their WIP, and provide a process for mediation and investigation. Following an investigation, a report may be sent to this committee, PROC, for further action, who in turn may bring it to the House's attention if discipline against the member is contemplated. Any changes to the code would originate through PROC and would ultimately have to be adopted by the House. Currently, there is no regime that addresses harassment of non-sexual nature between members. Finally, the House of Commons has a policy on harassment and violence prevention, which governs the House of Commons administration. This policy of harassment prevention and resolution in the workplace was first approved by the Clerk of the House on the advice of the Clerks Management Group on April 1st, 2015. Following the legislative changes to the Canada Labour Code Part 2, our current policy was approved March 24th, 2021 by the Clerk of the House of Commons, again on the advice of the Clerks Management Group. The legislative required a review of policy is presently ongoing. And
Ms. Evangelista, sorry to interrupt. We're a minute over, so if you can wrap up, please. Thank you.
Yeah. I would actually conclude over our opening remarks by emphasizing that the House administration is dedicated to fostering a safe, healthy, and positive workplace, and we're happy to answer questions that you may have. Thank you.
Thank you very much. Colleagues, we will now begin the first round. As you know, each party will have 6 minutes. Mr. Calkins, I believe you're the first up, so the floor is yours.
Thank you, Chair. Thank you to the witnesses for always coming to this committee whenever we need to hear from you. I guess I will let you decide who is best positioned to answer the question based on the nature of the question after you hear it. So I just want to be clear about the jurisdiction, so understanding jurisdiction here. the jurisdiction of the members of the House of Commons Workplace Harassment and Violence Prevention Policy, what is that jurisdiction?
The jurisdiction for that is largely members as employers, so it targets largely the employees of members.
And it does not deal with member-to-member interaction, just so we're clear.
That's correct.
Who would have jurisdiction to make a decision about anything that happens between members? Where is that jurisdiction?
I'll maybe turn this one over to Michelle, but I think that's where there's a bit of a void.
The House will unquestionably have the jurisdiction to govern the conduct between members to members and put in place a regime as it did for sexual harassment.
Right.
And the House, for such matters, will oftentimes act on the recommendation of PROC, and actually the first order of reference to this committee in 2014 contemplated that the study and the ultimate code will cover all form of harassment, but ultimately the report only covers sexual harassment. Now, if Boy was to put in place a regime that were to intend to apply members to many by the House, if we're talking about suspensions or any other sanction that requires a decision from the House, but unquestionably, this committee has the authority to make a recommendation on member-to-member harassment.
So that's a bit of a challenge, obviously, because the chamber, the House, is designed to be adversarial. So can any of you offer members of this committee any advice on the definition of adversarial versus the definition of harassment? Because it's designed to be that way. And members of Parliament do feel uncomfortable. We're made to feel uncomfortable by our constituents. We're made to feel uncomfortable, and we shouldn't feel comfortable in our jobs. This is the nature of our democracy. So in the delineation of feeling uncomfortable because of the duties in the adversarial environment that we're in by design, how do we rationalize what is feeling uncomfortable through harassment or feeling uncomfortable because you just got political pressure put on you in an adversarial system?
It's a very good question, Mr. Calkins, because you're right. The House of Commons is a very unique workplace with a very unique mandate, as you just described. So any definition in terms of what is acceptable, I guess, the acceptable roles of members in the House, either on the government side or opposition side, versus what falls into the area of harassment is something I would anticipate this committee would want to reflect on if it was decided to go that route. And I think any regime, if one was to be put into place, would have to take into account the fact that proceedings in the chamber and in committee are overseen by parliamentary privilege. Maybe, Michelle, you want to expand a bit on that?
If I may, there are some jurisdictions that have adopted a code of conduct.
Sure, I'm having a hard time hearing. Can you move your microphone, Mr. Bedard?
Okay.
So, yeah.
Is it better this way?
Hope so.
Okay. There are some jurisdictions that have adopted a code of conduct that will apply to all form of harassment, but they carve out parliamentary proceedings. So, for example, the Senate has a policy that will apply to conduct between senators, but it does not apply to all actions that are taking place during parliamentary proceedings. Everything that is taking place during parliamentary proceedings will be addressed to the procedural means that are already available, be it a question of privilege or question of decorum, that are usually enforced by the chair or the speaker.
Okay, thank you, Chair. So my last question is then, what constitutes the parliamentary area? Just for clarification, the House of Commons obviously does, a committee space does. Our offices and any place in the parliamentary precinct, what about our constituency offices?
Normally, in terms of parliamentary proceedings, in terms of privilege, it's just the House, the chamber, and committees.
Well, we can attend the chamber from our constituency office. We can attend the chamber from our house. We can attend the chamber from anywhere in Canada as long as we have an adequate internet connection. Yeah. This needs to be clarified.
Right.
The concept of parliamentary proceedings will exist whether you participate in proceedings through virtual means, through Zoom, with the video conference as authorized by the House. So the jurisdictions that have applied harassment to all conduct will have carved out the parliamentary proceedings. That I gave the example of the Senate, but there are other examples in Canada that have carved out parliamentary proceedings from the applications of their code of conduct or policies when it applies to members
See, I don't differentiate.
Mr. Calkins will have
Sorry.
to wrap up right away.
Thank you, Mr. Chair.
Okay, thanks very much. Ms. Romanato, over to you for 6 minutes.
Thank you very much, Mr. Chair, and through you, I'd like to thank the witnesses for being here. As you mentioned, it was recommended to PROC that this be looked at almost 10 years ago. So I don't want to say delighted that we're actually getting to it because it took us 10 years, but I have a list of questions. Mr. Calkins actually got a few of them in, so that's good. So right now, as you mentioned, the current members of the House of Commons Workplace Harassment and Violence Prevention Policy does not cover harassment between members. So what would be the recourse for a member of Parliament who is undergoing harassment by another member? What would be their recourse at this point?
Thank you for the question. So as it stands today, we're always encouraging, we really review it case by case, right? So you are able to come forward and actually speak to us, and it really depends on the situation. We also work very closely with the Sergeant at Arms to ensure from a safety perspective. So I think, that's our first line of defense is reviewing every case, making sure that the environment is safe from a physical safety perspective. Then what we do is, should it be under the Code of Conduct sexual harassment, then we go that route. If it is not, then we actually refer you back and with a whip. And there, yeah.
I'm going to cut you off
Yeah.
because I have lots of questions, so my
Yeah.
apologies.
Yeah.
So not dealing with sexual harassment, not physical safety. What I'm talking about is, say, psychological harassment. And my home province of Quebec was one of the leaders in terms of bringing forward legislation to prevent workplace psychological harassment. So right now, there is no recourse really available. And from what I understand, there is no even mediation available to members of Parliament that are undergoing psychological harassment. Is that correct?
There's always, Phil, thank you for the question. There's always an opportunity for the member HR team to actually provide any type of support. So there are external resources, there's coaching available for you. It's just the recourse is not there, as you mentioned.
And you mentioned that in the event of a situation, a member can go to their whip. Do whips and deputy whips of caucuses receive basic human resources training or harassment prevention training? And if not, would you recommend that they do so?
Yes, thank you. So every member of the House of Commons actually does receive the training and is available to them, including the whips.
Okay. Now, my colleague mentioned how would you define the workplace of members of Parliament because of the multiple jurisdictions in which we work. So right now, would we fall under the Ontario Occupational Health and Safety Act, or because of the multiple jurisdictions, where would we fall as members of Parliament? Because we could be at an event, we could be traveling, we could be in our constituents, we can be here on the Hill. What jurisdiction do we fall under?
I'm going to refer that to Michelle.
As a member of the federal parliament, your workplace will be governed by the Canada Labour Code Part 2. So that's the authority. Now, traveling, it's possible that there might be some other health and safety regime that will kick in depending on if you have an event in another workplace. But you as an employer and your workplace, the constituency office, is governed by the Labour Code.
Okay. So I have a weird question. It may sound a little weird, but I'm going to give you some context. In May of 2015, the Reform Act amended the Parliament of Canada Act, and it requires that the first caucus meeting after an election, 4 votes must take place, including a vote on the expulsion of a caucus member. Has a legal opinion been sought out to ensure that this is in line with labor laws? For instance, if a member is undergoing harassment and or a victim of harassment, what's to say that if their caucus has passed the Reform Act to allow caucus members to kick out a member of caucus, essentially with 20% of their caucus, how could this amplify harassment or actually even prevent a member from coming forward out of fear of reprisal by being thrown out of caucus?
Thank you for the question. That's indeed a very interesting question. The Reform Act came into force and was implemented before the Labor Code was put in place. I will say my preliminary opinion, they govern different things. As you know, caucus have to decide which portion is to be applicable to their caucus. It applies to the membership, expulsion of members, also leaders may be subject to a vote by their caucus. I would not qualify the exercise of power under the Reform Act as potentially an act of harassment, as members are exercising their right under the Parliament of Canada Act. Same thing when they are participating in proceedings in the House and voting. I'm afraid that's all I could offer today, but that's indeed a very interesting question.
Okay. Do I have any more time? No?
Unfortunately not.
I'll maybe get another round. Thank you.
Merci. Madame Gaudreau, à vous pour 6.
Thank you, Madame Gaudreau. You have 6 minutes. Thank you very much, Chair. Well, after all this time, I have the impression that we're actually going to get there. I'm pleased that we're able to raise our concerns because, in fact, a member's role is very broad, and there is a large gray area. There is a lot of parliamentary jousting, and I think that this is an excellent opportunity to define, and actually here, to determine what is legitimate, what can hurt. This is where we are now. So as far as I'm concerned, I hope that we will be able to quickly come to an agreement with criteria which will resemble what we've seen at the Senate, criteria which could resemble what's being done in Quebec's National Assembly, because we can't not deal with this. Now, I have understood that when we're talking about member to members, we're in the right place. That was really my initial question. What is the role of boy? So I'm reassured. You also talked about procedures, but right off the bat, I'd like to hear from you about what steps we should be following so that we can have a report, recommendations, and pass it in the House quickly. So I don't know who would like to try to address this. Perhaps I could begin, and my colleagues can add. I understand your concern wishing to proceed quickly. We have to take everything into consideration. As Carolyn was saying last time, when the code was created, it was done by a subcommittee, so that's one option. You could create or recreate a subcommittee that takes the time to review the issues, and we could assist and come back to the committee and then to the House with recommendations. I don't know whether Michelle or Caroline, you have anything to add to that? The process as described applies if the committee were to recommend amendments to the Sexual Harassment Code of Conduct, which is within the purview of this committee, and then make recommendations to the House. A subcommittee, as has been recommended last time, would perhaps be form that was considered in the past to be more appropriate for this kind of discussion? If the decision were to be to make amendments to the policy, as I mentioned earlier, the policy was adopted by the Board of Internal Economy, so it's the PROC cannot make changes. If after deliberations the committee wants to see changes to the policy, then I think the idea would be to invite Boy to review the matter. So what I've understood is that we have to do our work for the portion that involves member-to-member behavior, but that we have to work together with the Boy because the sexual harassment policy is complete, but it's missing this part because we've had training, because we're employers, and I've understood that part. Right now, the code applies to sexual harassment. It's very tempting to say we'll simply remove the word sexual and then and that'll resolve the matter. But that would be the beginning of the work to be done. If the political will was to subject everything to this code of conduct, that is one thing, but you have to examine what the other exceptions would be. You talked about parliamentary proceedings or debates, and it's more than just removing the word sex or sexual in the code. There are other amendments that would have to be made. In terms of time, with having a subcommittee meeting with Boy, making proposals, what's reasonable in terms of a time frame? Last time it was brought to us, I think the committee took about 6 to 10 meetings before they were able to bring forward everything. So I would recommend a similar amount of time to ensure that all the necessary studies have been done to be able to bring to you the best possible recommendations for Canada and even internationally. Last question. I have 30 seconds left? Do you have everything to be able to make the proposals, or do you have to do any other work? Well, we have certainly already done work, but we can do more. Thank you. Thank you very much, Ms. Gaudreau.
Listen, we will go to you. I will just note that at the tail end of your questions, there may be bells that we have to deal with, but for now, we're in the clear. So I turn it over to you for 6 minutes.
Okay, I'll power through, Mr. Speaker. Thank you. This is all incredibly interesting. One of the reasons why I was so interested in ensuring that this study occurred, I sat as a staffer on that subcommittee. And it was all done in camera, so I have to remember what I can and cannot say overall. I'm sure we all appreciate that. However, as was noted, we started with a much broader mandate. And because there could not be any sort of agreement whatsoever under that current government and makeup of the committee on what harassment was, we were forced to come up with that much more narrow agreement on sexual harassment, which was truly disappointing for me as a staffer, let alone not knowing where my future would lay and as an actual legislator. So I think that although it took 10 years, it's really important to get here. I'm interested to hear your perspectives on the change of culture. It was mentioned that we are a historic adversarial type of workplace, but that doesn't have to necessarily be the case. We have the power to change that. We have the ability to change that. There has to be a desire and political will to change that. But I'd like to see, there have been a number of new security programs initiated. Parliamentarians are now offered trial programs through PPS security, off precinct. You know, there's been panic buttons for some time, but all of these things are being added to our constituency office for sure as well. I would like to know observations on the rise of harassment and violence in Canadian politics overall, the deliberations around creating these programs, and what has been the driving force in terms of that increase. in incidents.
Maybe, Pat, can I just quickly start and then hand off to you? You're right, there absolutely has been an increase in threats and what have you to members, often anonymous threats through social media or what have you. That's almost a completely separate subject, and Pat can speak to it in terms of what measures have been taken to date to assist members in addressing that. But that is a separate subject from the issue of member-to-member harassment. But I'll let Pat update the committee in terms of what's been done recently and what's up ahead.
Yeah, I can note that their state...
Sorry to interrupt, Mr. McDonald. I do see that we have bells that have just begun. Colleagues, I'm looking to see if we have unanimous consent to work through the bells, and also if committee members are comfortable voting electronically. That keeps us all here and allows us the opportunity to move forward. But if not, then...
No, I
Okay.
need to vote in person,
No,
but I would
yeah.
be prepared to go 5 minutes until.
Okay, sounds good, colleagues. So we will restart the clock in a moment, and we'll keep an eye out for 5 minutes before votes. Members can, of course, choose to vote electronically or in the chamber. And then once we have all members back, if that happens before 10 minutes, great, we'll get going. And if not, then at the 10-minute mark, we will begin again. Mr. McDonald, apologies for the interruption. Back to you.
Yes, so there's been a significant increase in the last 5 years in harassment of of the members of Parliament, mostly online, but also in person and at events, and by significant, probably in the tune of 700-800% increase. And the same for, to give you an example, on threat behaviors towards towards the MPs. In 2019, there was approximately 8 files we opened up on threat behaviors towards either a direct or indirect threat towards an MP, and in 2023, there was 530 files opened. So that's a significant increase of threats and threat behavior, mostly threatening behavior towards the members of Parliament. For the harassment of MPs online, it's come to the point where we're bulk filing the harassment of MPs online. That it's so bulk filing, there's just so much of it, and the social media platforms are, one, either not taking our call or taking our call and saying, yes, we'll look into it, and it ends there. Because it's according to their rules if they take it down, the malicious or harassing posts, and it's up to them to take it down. Anyone can report it in if the post doesn't meet their rules or regs, but it's up to the social media platform to remove it. And we're not having much luck as of late having them remove it.
So while that might be a separate question versus member to member, it certainly would have an impact on members, certainly has an impact on staff. So as an employer, what obligations do we have around that impact?
The 1 minute remaining.
So I think, again, it's about providing a health and safety environment. I think that is the most important. So it's about, if you come and speak to us from an HR perspective, we have resources. We have nurses on site. We have actually a respectful workplace that could support employees, making sure that from a mental state perspective, they feel safe. We have training available. Of course, we're not going to, eliminate it, but it's about mitigating the risk for reoccurrence. So that is an obligation that we do have.
And I guess I don't know if I can get it in. Maybe I can bank my time if the chair is so kind.
20 seconds, Ms. Matheson. Happy to roll it over for next
Thank
time.
you. I request that, sir.
Good. Okay. Thank you very much, Ms. Matheson. Okay. Ms. Ferrari, over to you for 5 minutes.
Thank you so much, Chair. Thank you for having me here. It's my first time at Proc. Thank you for this. This is a very interesting study that I have plenty of personal experience with. I'm sure you've seen my name in the bulk files many times. I guess my question to you about when we're talking about online harassment to members or that kind of thing, for you and your team, what do you have in place to support yourself to actually act on this?
Through you, Mr. Chair, we have an open source intelligence unit who employ a number of different softwares. And right now we focus mostly just because of the number of files, which are threats or indirect threats. That's our focus. And we reach out to the police force of local jurisdiction and the Royal Canadian Mounted Police, their protective operations. Once we feel, or if we feel that there may be criminal intent there.
I guess where I'm going with this is a couple of twofold question. We know our police are extremely inundated, overwhelmed. They also don't have the resources often to follow up, not just in this instance, but in many domestic violence instances. Many issues go sort of left to the bottom of the queue because there is so many other issues, whether it be overdoses or, you know, calls of those kinds of things. So my question is twofold. Number one, I'd be curious to have the data, if you want to table it to the committee, how you've had to change your staffing, and have you had to increase staffing and resources, and what does that cost look like? And in what time frame have you seen that jump? And then also, how do you prioritize if your resources are spread as thin as they are in, say, the instances of police?
Real quick. In terms of police following up, I think what's often frustrating for members, and it's a genuine concern, is, and it's maybe a more legal question, the definition between when harassment becomes a threat and becomes criminal. And that's often a fine line. In terms of staffing, very recently the Board of Internal Economy adopted a significant increase in resources to assist the Sergeant-at-Arms and his team that work closely, of course, with Parliamentary Protective Services and the RCMP and other jurisdictions. So maybe, Pat, you can give a bit of detail on what that will see us have going forward.
So, as the clerk said, there's been a significant investment in my area in the last month to resource us up and keep our nose above the waterline and deal with the massive workload which we are now facing. We're very confident that we'll be able to handle the workload for the foreseeable future. In regards to the cooperation with the police force of jurisdiction, we deal with 91 police forces. We have agreements with 61 to provide paid duty at members' events and provide security when a member hosts or attends a public event. To date, the RCMP have been excellent to move quickly on files that may have a criminal intent or.
What is your key and what is your timeline that you have as your goal to respond? Do you have one internally that you're saying, okay, we've received this message, we have a timeline that we've put in place for us to follow up?
We try to get our files as quickly as possible. If there's a threat there, we'll same day get to that file. Often within minutes, we get to the file, and sometimes with the cooperation of police force of jurisdiction and the RCMP, we can act on the file the same day. And I had an example of that in recent memory where the threat came in against a member of Parliament in the morning, and the person was in custody out west in Western Canada by bedtime.
Your team has been amazing when I've had to reach out, so I do commend you on that. The other major question I think that a lot of people online are having is
We're at about 20 seconds.
20 seconds is bots, differentiating between a real person and a bot. What are you doing to ensure that?
Well, that's my open source intelligence team, and I would have to come back to you with an answer because that's getting into technical information that I don't quite understand.
Thanks very much, Ms. Ferrari. Next, we have Ms. Dama for 5 minutes.
Thank you, Chair, and thank you for the opportunity to sit into the PROC committee today. I want to follow up on the line of MP to MP harassment. And when it was asked about social media, I think, Mr. Jantz, you said that's a separate matter or a separate subject, except my question is, what happens when an MP puts on social media something that directly drives harassment of the MP? So they mention another MP specifically in social media, which in turn drives phone calls, emails, and social media threats and misogyny. And I've been subject to that repeatedly. So I would argue it's not a separate subject. And I don't know how we deal with that, but I just wonder if you could talk about the impact of MPs' social media on other MPs.
No, thank you for the clarification, Ms. Damoff. And you're right. When I spoke about social media as separate, I meant like members of the public, anonymous people sending threats and the like. But you're right. Sometimes you have occasions where there is member-to-member exchanges on social media, or what you're alluding to, a member does something that causes an impact then on another member. It again becomes a bit of a jurisdictional issue. For instance, the speaker has jurisdiction in the chamber between interactions between members, but has no jurisdiction over exchanges between members on social media. You know, Michelle, if you want to add to that.
Well, currently, there's no House instruments that will govern this relationship. The Code of Conduct sexual harassment is limited to sexual harassment, as its title indicates, and the policy does not apply to member-to-member conduct. Of course, if the tweet or what is posted on social media reaches a certain threshold that it's criminal harassment, then it will be subject to the criminal code, but we haven't had any example of such a matter.
So I'm not talking about the actual MP and criminal harassment. I'm talking about the MP tweeting, for example, knowing that, with misinformation often, but targeting another MP. So the MP says Pam Demoff has just compared every hunter in Canada to the Danforth shooter. And then what follows from that is the very large gun lobby sending much more than mean tweets, which is what they've called them, but they've been threats and absolutely horrific messages to my office, phone calls from across Canada, which impact my staff. So it's the MPs, what they have tweeted has directly resulted in harassment of my staff and myself. So it's not the MP saying the criminal harassment, it's inciting other people to do so.
Currently, there's nothing, no House policy or code of conduct that will address such a behavior.
Do any other jurisdictions have policies with respect to MP harassment?
Yeah, so there's 9 across legislative around Canada that do, and internationally as well. Both UK and Australia also have an MP to MP.
Would you be able to share those policies with us?
Absolutely.
Okay, yeah. Thank you. Yeah, I wanted to talk a little bit about our staff, which Ms. Matheson brought up, because while there are resources available to them, I often hear people say to me, "Well, you don't have to look at your social media," but the problem is somebody is looking at it. My office set up a whole subfolder in our inbox called misogyny. So maybe to talk about how this is impacting staff.
Yeah.
In 20 seconds.
we encourage you to actually let us know. And like mentioned earlier, there are mental support for the staff, and we want to make sure that they feel secure themselves. So I would encourage for us, Pat also shares with me whenever there are instances where there are tweets that could harm the staff, and we're proactively reaching out as well to make sure that they're okay.
Thank you.
Thanks very much. Madame Gaudreau, c'est à vous encore pour 2 minutes.
Ms. Gaudreau, over to you for 2.5 minutes. Very well. Thank you, Chair. Given everything that we've heard, I think we can conclude that it is important and urgent to have a proposal and have a subcommittee to be able to examine what exists elsewhere, what's worked well. In some cases, there's some catch-up required. When the Sergeant at Arms is telling us that we have 700% to 800% increase in online harassment, this says clearly that our efforts have to increase at the same pace. Right now, we can't keep pace, so let's take advantage of this opportunity. On behalf of democracy and public safety, when I meet people in my riding, not only do they tell me, are you going to still continue? How do you feel when you're treated that way or called that way? And when I talk to my kids who are 20 years old, they say, I'll never go into politics. But often when I meet colleagues in other jurisdictions who have resigned because of the harassment that they received within their organizations, I think the time is ripe. We must proceed with this revision, and we can talk for hours and hours, but we have to be constructive and set up a subcommittee and work together with Boy so that beginning in September we can make proposals so that we can do this before the end of 2024. I'd like to know your opinion about this. I understand your recommendations. We take them, and we are prepared to assist you. Thank you. That's it for me. Thank you. Excellent. Thank you very much, Ms. Gaudreau.
30 seconds from the previous round, so you're
Excellent.
at 3 minutes, okay?
Excellent. Thank you, Mr. Chair. So I'm interested to talk more about that parliamentary privilege divide. Of course, that is so key in terms of our democracy, that freedom of speech is so incredibly important. It is one of the basis of this place, this institution. But there have been limits placed upon that in previous, with the sexual harassment policy, member to member. So where are the boundaries? Like, where does parliamentary privilege end? Can you talk about the principles of how we would decide even upon that? Fine lines, your worries about that as well.
As was alluded to, there are several jurisdictions that do have codes to govern member-to-member behavior, and I think the vast majority of them deliberately and explicitly exclude what goes on in the chamber and in committees. And the goal, I think, in that is to protect the privileges of members in their deliberative functions and ensure that any situations that arise in those forums are dealt with according to the procedures and the rules in those forums. So there's a speaker who is responsible for ensuring decorum in the chamber. There is a chair who is responsible for maintaining decorum in a committee. And there are processes by which the House can sanction misconduct should it occur in those forums. So a lot of, I think the vast majority of codes that other legislatures have adopted have deliberately carved that out with, I think, the fear of what would members welcome, for example, outside investigation into what goes on during proceedings? I guess that's the question that members would have to decide in considering that.
In terms of those boundaries and what those chairs within the House or committee have, do they have the proper tools already existing to be able to do that job? Do they have the appropriate training to do that job? Is that something that we need to work on as well?
I think that would be a question for members to decide. That there is, I think, certain standards of decorum that are expected and that that are attempted to be enforced. Whether members think those standards are sufficiently high, I think, is a question for members to answer, and whether or not the sanctions available to the chairs or to the speaker are sufficiently high, I think, is also a question members could consider.
Decorum is pretty general term and broad term.
Yes.
So again, it comes from an individual's will to abide by those entirely.
Yes.
And there would be no other option.
I would say if members feel that stronger tools are necessary or stronger sanctions are necessary or different processes are necessary, they would have to incorporate that into the rules. But as multiple speakers have said in multiple rulings about decorum, about language, it's impossible to achieve that, I think, only by enforcement. Members need to have the will to also govern themselves appropriately.
So as a
I'm sorry
workplace.
that's
Oh,
the
that
end
was
of
a
our
really
time.
fast 3 minutes. Oh.
I'm sorry. Colleagues, just a quick note before we go to the next line of questioning here. So we're going to hit just right at 5 minutes. I'm going to suspend at that point. We go vote. Once folks are back, we're going to continue. We will have one more from the Liberal side and then an entire round subsequent to that. And then that will bring us to the end of this morning's testimony. With that, for 5 minutes, I turn it to Ms. Rempel-Garner. Welcome to Proc.
Thank you, Chair. Mr. Jantz, has the House ever undertaken a legal analysis of what portions of various labor codes, be it provincial or federal, apply to Parliament or to the workplace of parliamentarians?
It's a good question, Ms. Rempel-Garner. I'm not aware of any, but maybe Michelle would have some details.
Until changes to the labor code in 2019, which came into force a year or 2 years later through what was known as Bill C-65, which made applicable to amendment to what we call PESRA, the Parliamentary Employment and Staff Relations Act. Prior to these amendments, the health and safety provision of the labor code were not applicable to Parliament as a workplace. That said, there were provisions, policies in place at the administration level, but there was no specific legal requirement except the general legal requirements of employers.
What about provincial labor code?
Provincial labor code will not apply to federal entities. They were really subject to federal legislation, so that's why until amendments were made to PESRA and then to the labor code to make it applicable to parliamentary employers, the provincial labor codes were not applicable.
So if someone was to say that they're entitled to a safe workplace here, parliamentarian, the federal or provincial labor codes would not apply in that sense outside of the amendments that were made in legislation in 2019. Is that correct?
Well, the changes that were made to the legislation in 2019 made applicable Part 2 of the Canada Labor Code almost in entirety with some adjustments, minor adjustment to Parliament as a workplace and to all parliamentary employers, including members.
Thank you. I have made a very purposeful choice in my career to not platform any of the harassment that I've received, and I will continue that. I will say, because it's a matter of public record, that I think I was the first case of criminal harassment that was prosecuted on Twitter writ large. Mr. Jantz, your team here has talked about the fact that there are criminal laws regarding harassment. What services do your team offer to link parliamentarians with the appropriate legal services when instances of criminal harassment occur?
It's very much a partnership, I would think. Our Office of the Law Clerk is involved, the Sergeant at Arms Office is involved, our IT folks who are in close contact with some of the cybersecurity institutions are involved, police forces of jurisdiction, Parliamentary Protective Service, so there's a lot of players involved. But maybe, Pat, you want to give a bit more detail?
A typical case would be made aware of the complaint. First contact is RCMP, And second contact with the RCMP is police force of jurisdiction. We reach out to them. The case is discussed. Often it's obvious that it is a criminal harassment case.
At this point, though, it's fairly, it would be reactive, right? So in terms of your team offering those, that making MPs aware of like what to do in those circumstances, it's reactive right now. Is that correct?
Yes, ma'am.
Thank you. Perhaps that's something that the committee could consider as a recommendation. I remember a time where a colleague of a different party gave a 5-minute missive in the House of Commons about the fact that I had blocked them on Twitter after they had sent a lot of junk my way. I would just, colleagues, with this 45 seconds, since I'm segueing into this committee, I would just urge colleagues on their recommendations to ensure that we are not using legitimate, if there are recommendations that they're made on legitimate grounds, not as a way to litigate partisanship. And I would hope that whatever recommendations come out of this study, that partisanship is removed and scoring partisan points is removed, because this is a really serious issue. Thank you, Chair.
Okay, thanks very much, Ms. Rempel-Garner. Okay, colleagues, we are going to suspend in order to deal with our voting responsibilities, and we will come back shortly thereafter. Thank you. Our witness testimony here. And with that, I turn it to Ms. Romanado, who has 5 minutes remaining in this round.
Thank you very much, Mr. Chair. And through you, I'd like to ask the witnesses a couple of other questions. We're not talking about privilege here when we're talking about closing the loophole with respect to MP harassment. I think, when I talk about privilege, let me rephrase that. What I'm talking about is not having healthy debate in the chamber. I think we should absolutely have healthy debate in the chamber. I think we should absolutely be questioning policies. We should absolutely be providing feedback to improve legislation. But when it comes to sometimes the civility in the House, when it comes to personal attacks, when that kind of behavior then spills out into social media, so that a member now is refraining from either going to the chamber or participating in debate or self-regulating what they say out of fear of all of that happening. Now we're into privilege. Can you comment on that? The fact that if we have members not going into the chamber or not participating in debate out of fear of what's going to come out on social media or their emails or the phone calls to their constituency, we are now prohibiting MPs from participating, and that is a point of privilege. Mr. Jans, can you elaborate a little bit on that?
It's a very good question that you raised, Ms. Romanado. Again, issues of decorum and what flows from that in the chamber, there are, as Jeffrey alluded to a bit earlier in response to a similar question, there are procedures and practices in place to address that. I'm not sure that changing the code would necessarily have a direct impact on that. And again, most jurisdictions carve that out as something to be treated separately. But obviously, no, you would not want to see members refraining deliberately themselves from attending sittings in the House because of fear of what could transpire or happen, either in the House or thereafter, because ultimately that's why they've been elected, is to represent constituents in the chamber. I don't know, Jeffrey, if you wanted to add.
I think we would all share the objective that members should be able to come and speak freely and without fear of consequences, and I think that's the entire concept of parliamentary privilege is meant to protect. The question you raised, though, is a tricky one about when members are then subjected to harassment or targeted for harassment for things that they have said after the fact, and how does one best handle that? And I think, if I understood you correctly, it's not necessarily what they get from other members, it's what they get from the general public, and the types of attacks that are now very easy to make behind one's keyboard in one's basement, and to do so very often anonymously without any consequences. And it's an interesting challenge to how to reduce that risk, and I think the platforms themselves have some responsibility in trying to police that, and I'm not sure if I understood Pat correctly that that's a responsibility they're taking very seriously today.
So I know all of my colleagues here today have gone through this. So in our parliamentary work, whether we're in committee right now, and I'm sure I've probably already got some emails in my inbox based on the questions I'm asking you today. Snowflake, can't take the heat. Oh, maybe, women, can't take it, don't run for office. What would you say to people who are considering this profession, who see what some people post on social media, who see some of the harassment that MPs go through, whether it be at an event, whether it be, in the grocery store. I can't buy ice cream at my grocery store because normally people stop me and they're asking me questions, and by the time I get to the cash, it's melted. And that's actually a good thing. But that being said, when people are thinking about this job, we have a responsibility on the civility in the House as well, whether we have a decorum or not. I think we do have a responsibility as colleagues. Nowhere in any other workplace would some of the behavior that we see be acceptable. Any other workplace in Canada, the person would be terminated. What can you say to people who are considering this profession, given everything that you see that we go through?
About 20 seconds.
It's a very good point. I mean, I think we all find it tremendously unfortunate what members and prospective members are subjected to. I would hope that would not overly discourage people who have an interest in public service from nonetheless putting their name forward and seeking election and making a contribution to Canada and Canada's Parliament. But you're absolutely right. It is a concern for many, and certainly our team, to the best that we can, is there to support and to help.
Thank you, Mr. Chance. The floor is to a Conservative member, but I don't have a member. Ms. Rempel-Garner? Okay, you have 5 minutes. The floor is yours.
Thank you, Chair. Mr. McDonald, in your conversations with law enforcement, has there ever been any discussion about the need for clarity in law around what constitutes online criminal harassment, or perhaps additional tools that law enforcement could use, or that there's a gap in right now to de-escalate behavior or to prevent it from escalating?
Through you, Mr. Chair, I don't recall, Madame, having a discussion of that nature with law enforcement partners.
The reason why I ask is because we're having a conversation now on online, essentially the broader issue of online harassment. And I know that the RCMP there was an article, I believe it was in the CBC last week, saying that the RCMP is recommending additional tools for members of Parliament to prevent from harassment. But my reaction to that was, well, if they can't protect me, then how are they protecting everyone else? So I'm just wondering, based on your experience, if you would have any suggestions that the committee could recommend to perhaps close some of those gaps. Like, for example, the fact that it's very difficult at present, or it's gray to understand, like, when and how law enforcement can find the identity of somebody who is repeatedly, and not like one-off, but like repeatedly harassing somebody online in a threatening way that could become criminal, be deemed as criminal harassment.
Yes, I think there's lots to be done, can be done, and should be done in relation to the harassment of members of Parliament, politicians in general, and the general public. When we first started up our open source intelligence unit, we focused on the harassment of members of Parliament, and we had great contacts and on the social media platforms, and would ask them to take down posts that were against their own regulations. Well, in the last few years, that's fallen by the wayside. Sometimes they answer the phone, sometimes they don't, often they don't. I was speaking earlier before we came back about Twitter used to be our best contact for bringing stuff down off of social media. And once the new owner took over, the people, our contacts there, were let go. And now there's nobody to contact at that particular social media platform to bring down information.
At that time, when you talk about bringing down information, did the House have a clearly defined set of guidelines on when they would ask for something to, quote, be brought down? I'm just concerned about...
Yeah, sorry.
It sounds like impingement on speech, potentially.
Well, it was just their regulation, the terms and conditions of the social media platform, if they were breached. And we would only contact the social media platform with the authorization of the MP. We would not go out on our own. But anyone can contact the social media platform.
It seems to
citizen
me,
can.
based on this conversation, that there's a gap between understanding, or there's a gap between what is clear in law in terms of what constitutes online criminal harassment and what tools could be used to either prevent the escalation of that happening when there's a clear pattern of behavior. And I'm not talking about like a single mean tweet or something. I mean like a clear escalation in harassment. And what is actually being used in practice right now. It seems like a bit of a hodgepodge. Would that be a correct assessment? And I'm not saying like ascribing motive, or it seems like there's a lack of clarity in law in this regard.
I would agree.
Thank you. I'll close with this question. Since this committee was last seized with this issue, I think that there was a purposeful decision taken to not include MP harassment in the changes to the labor code. Has your shop, Mr. Jantz, given any thought to how non-sexual harassment would be defined? I know that this has already been discussed somewhat today, but has there any thought been given to that by your team?
About 30 seconds, please.
Not considerable, but I think you, Carolyn, might have a standard definition that's often used.
In 30 seconds, I would say there is already in the harassment prevention policy a definition right now that we could definitely be reviewing. But there's always the Canadian Human Rights Act, right, that we can actually look back on and make sure that we're taking the best of the definition and putting it forward.
Thanks very much. Ms. Shanahan, over to you for 5 minutes.
Well, thank you very much, Chair. And actually, I'd like to take up that last point because there does seem to be some confusion here among the members as to what constitutes harassment. And so I refer to the code that already exists for harassment and violence in the workplace, Appendix 1. And I find it very thorough, but it is clear there that harassment may include, but is not limited to, offensive or intimidating comments or jokes. There's another point about abuse of authority, which doesn't apply here because this has to do with employers and employees. But it goes on to say, spreading malicious rumors or gossip about an individual or group, cyberbullying, threatening, spreading rumors, or negatively talking to or about someone online or on social media, socially excluding or isolating someone, persistently criticizing, undermining, belittling, demeaning, or ridiculing a person, psychological harassment. I'm picking out the ones that I think are most pertinent to our discussion here today. Sexist remarks, racist remarks, homophobic remarks, transphobic remarks, verbal threats or intimidation, and so on, making aggressive, threatening, or rude gestures. Harassment is not. And the first point has to do with management responsibilities. But the second point, very pertinent to our discussion today, harassment is not a disagreement regarding a policy or practice. So I would ask you, does this constitute a good basis to address this gap in the member-to-member code of conduct, if you will, regarding non-sexual harassment?
I would say yes, but there's definitely a study to be done in the context of the environment.
Excellent, because I think what we've heard today are examples, too, of how social media, which is a tool for all of us, is being weaponized, effectively weaponized by members. And in some cases, our social media accounts are actually paid for by the House of Commons, so it does come under the purview of our MOB. Or our staff operate our social media accounts, so they're salaried staff there. And, we can talk about, I appreciated the points that Ms. Matheson made. We can talk about the effects of staff both in dealing with social media and also producing harassment media. Is what I'm hearing that this gap really has to do with, it's one thing what is governed within the House of Commons by the Speaker or in committee by chairs, but once it leaves this House by the vehicle of social media, and this is what is brand new, is this not an area where it behooves us to put a policy into place? I'm thinking, Monsieur Bedard, too, historically, in the House of Commons, we have two sword lengths, do we not, between the opposing side? Because there was a time that physical violence, and God forbid, I hope we never get to that point again, but the two sword lengths, I think we need to talk about putting preventive barriers around the use of social media. Monsieur Bedard, would there be something legislatively that would cover that otherwise?
1 minute remaining here.
Mm-hmm.
With respect to the two swords, we haven't taken any measurement recently. You alluded to some definition of harassment and examples. The definitions you alluded is actually in the labor code, and these were examples. Now, whether to the code of conduct, sexual harassment, or general harassment, if members want to start from the existing definition of harassment, which is applicable in the federal workplace, and adjust it to the savor of Parliament, because there is a unique component to Parliament as a workplace, the House of Commons. We mentioned parliamentary proceedings. Also, we need to be mindful of the fact that there are about half of the chamber that is called the opposition. You don't have that in any regular workplace. So, and the main role of the opposition is to oppose, to make sure that the government is accountable. You don't have that in a normal workplace as well. So, any measures that are to be put in place, if any, have to take into consideration the unique nature of the role of government, opposition in our system of government.
Okay, unfortunately, Shannon, that's all of our time. Madame Gaudreau, c'est à vous encore pour...
You have 2 minutes, 30 seconds, Madame Gaudreau. Well, I'm going to move along then. Chair, I just wanted to say that at the National Assembly of Quebec in 2015, did not distinguish between members and employees or anyone else. And it works out very well. We can look at the figures to see what, to ascertain that. I would say, listening to everyone, that prevention is essential. But when you talk about a code of conduct, and when you are dealing with an elected representative of who is 25 or another who's 75 years of age, do the exercise. Just reflect. What possibility, what is the potential for harassment for these two individuals? So really, I think that the younger members have to respect the generational difference and also understand what could be done 40 years ago is no longer acceptable in today's context. When I'm dealing with my daughters, even for me, something might be okay, but for her, it's non-negotiable. So we have chosen to be here. We have a role to play. And in respecting a code of conduct, I think that we should be able to fulfill those roles. I'm a member of this committee. I'm a sociologist as well and an entrepreneur, and I'm particularly happy to be able to cooperate and work with you. Thank you. If I have 30, you can have 30 seconds if you have it. So let's have an answer. What do you think? Well, we are there to support you and to help you make recommendations in your committee here, PROC. So you are there to discuss how to move forward, but we are there to support you. Thank you.
For 2.5 minutes.
Okay, I'll try and be brief. I have two big questions, unfortunately, within 2.5 minutes. So there's a concern of mine that as we try to move forward, and maybe this would be for the subcommittee to talk about, but to get the opinions of members of parliament on how we start to deal with these issues. Obviously, we want that to be protected. Do you have any advice for this committee on how that could happen in terms of ensuring that even former members who are not reoffering, current members can be protected in terms of anonymity? If we start to survey them, is there a mechanism in place that could do that on this issue? The other question that I'll squeeze in there is I wanted to ask about witnesses. We are seeing witnesses not come forward as much at committee. We are also seeing this clipping culture, these gotcha politic moments that are now turning on members of academia or those incredible stakeholders that we rely so much upon. What can we do to better protect them? They are protected under privilege, and yet when they leave here, their testimony is used against them to a point where they may not return, and that's really quite critical. So I'd like your opinions on that.
Maybe I'll start and others can jump in. In terms of a process of consulting either current members or past members, certainly that's one of the tools that's available to any committee in terms of how extensive consultations want to be undertaken. There might be a need for caucus consultations, see what each caucus has in terms of views. Your point about witnesses is a good one. Obviously, witnesses are a key component to committee proceedings and the testimony that they provide, and any actions that result in a chilling effect and discourage them from volunteering to come before a committee to provide their advice and their expertise is certainly a preoccupation.
Do those witnesses have any redress if things happen to them in that regard? There's no access to parliamentary privilege or parliamentary resources like we have in the same instance?
We have in recent years, very quickly, we have very recent years started to make available to witness some supports, especially witnesses who come forward. I don't know it's necessarily the situation you're describing, but witnesses who come forward in the context of very difficult studies, very emotional studies, where there's something very traumatic that they come to share, where we've been making available to them the same sorts of supports that would be available to members or other members of the House Administration, but it's a relatively limited thing at present. In terms of retribution, any sort of retribution against a witness for testimony they give could be punished as a breach of privilege. The expectation is that witnesses come here to share information so that Parliament can do its job, and anybody who seeks to silence them or to punish them for that is doing a disservice to Parliament and to the democratic exercise. But how does that actually occur? What does one do in order to ensure that they're protected is challenging, especially like what we're used to seeing is the sort of idea of reprisals from their employer, or like if you're a whistleblower and then you're sanctioned for coming forward, but then to be then subject to attacks in the public sphere online. I think it's a different order, and it's maybe not something we're as familiar with or as well equipped to deal with at the moment.
Thank you, Mr. LeBlanc. I will ask, we're heading into the final 2 lines of questioning, which will be about 10 minutes, but I will submit now that it would be useful, I think, to the committee for our witnesses to provide written answers to anything that members may have felt we didn't get the time to address substantively. So we would ask witnesses for your cooperation in that matter. We will go to Mr. Calkins for 5 minutes, followed by Ms. Dama for 5 minutes, and that will conclude our 2-hour panel this morning. Mr. Calkins, 5 minutes to you.
Thank you very much, Mr. Chair. I mean, these fine folks here do work for Parliament, so I'm sure they would make themselves available to come back if it was deemed necessary. I want to just, a lot of has been said about missing or gaps, missing rules or regulations or so on, but I just want to get a clear state of where we actually are. So notwithstanding the labor code issues and everything that's been brought up, we already do have criminal sanctions for harassment. We have criminal sanctions for hate speech in the criminal code. We also have civil law dealing with libel and or slander, which I'm not sure has been fully tested when it comes to parliamentary privilege. So in the context of those provisions being there, we also have a Charter of Rights and Freedoms, which is premised largely upon the Universal Declaration of Human Rights, which gives us freedom of speech, freedom of expression. And at what point do we encroach on parliamentary privilege, on freedom of rights, and including freedom of expression, and why aren't the other mechanisms that I talked about, the criminal sanctions and the civil sanctions, enough to govern this space?
It's a very good question, and I think would be probably a focus of a large part of the discussion of either this committee or a subcommittee as to definitions and boundaries. You're right, there's a lot that exists right now, but what I think we're sensing from some of the comments that have been made to date is that that is perhaps not sufficient, and there's maybe something in between that should be codified.
Perhaps. I'm not saying that. Is it an enforcement issue? Is it a resource issue? Is it an actual lack of rules or laws issue? I guess that's the nature of my question.
Thank you for the question. The various instruments you refer to, the criminal code, libel, slander, they have specific threshold, and those thresholds that are applicable will not be the same that will apply to harassment. The threshold for harassment in the workplace will be different. So you first will meet the threshold for harassment, then civil liability, and then criminal liability. One thing that I will add too, because you mentioned parliamentary privilege and that it hasn't been tested, even the criminal code makes explicit provision that hate speech provision do not apply to words that are spoken in the chamber. Same thing for legal action that will be, civil legal action that will be taken against a member or witness before for what they've said during the proceedings will be excluded, will be dismissed.
Yeah, I appreciate that, Michelle. I really do. But if something is spoken in the chamber, something is spoken in a committee, and it is republished on a social media platform, has that been clarified insofar as the tests of privilege and libel and or slander?
This will depend on the circumstances, and you're correct that there's no major ruling addressing the issue. If it's a exhaustive reproduction of parliamentary proceedings, there will be a common law protection that will apply, and it will be an absolute protection. If it's only an abstract of the proceedings that are republished, that will depend on the circumstances and the intention of the person who did the publication.
And would anybody like to weigh in on the public interest that's also at stake in this conversation about being able to disseminate information that happens during our parliamentary proceedings, and whether or not we should be including the public interest in this conversation?
I alluded earlier to the absolute common law protection for the publishing of the entire proceedings of the House, which is based on the public interest, the fact that people have a public interest to know what is taking place in Parliament, in committee. Same thing for when it's an abstract or partial reproduction. There is an exception that is made in the law that if the person did that reproduction in good faith, there will be a protection afforded. So I will say that yes, there is a general interest for the public to see what its representatives are doing to vote laws, to make sure that the government is accountable.
Okay.
Okay, that's about it. Thank you very much, Mr. Calkins. Ms. Damoff, to you for 5 minutes.
Thank you, Chair. I want to talk about physical safety in constituency offices. Recently, we got a notice from the Sergeant-at-Arms to keep our offices closed. My office is closed all the time now, except by appointment, on recommendation from Parliamentary Protective Services, and there's a sign on the door to that effect. But in particular, we got a notice a few weeks ago about climate Axe the Tax demonstrations. And that was something the Leader of the Opposition had called for the public to go to MPs' offices to demonstrate. And then shortly afterwards, we get a notice that we're to make sure that we're vigilant, to keep the doors locked. how dangerous is that type of call by politicians to act, and then it results in us as MPs being less accessible and also putting our staff in danger in community offices?
Yeah, so I was the one, as a sergeant at arms, that sent that memo out on that particular day to keep the offices locked. It wasn't related to what a political party here published. We picked it up off the intent to visit MP offices. We picked that up from a group who had posted on the internet that it was their intent to visit members of Parliament offices and protest. So that's why that was published. And also we picked up off the open source monitoring the possibility of demonstrating at residences of members of Parliament. And indeed, over the past months, there have been demonstrations at certain members of Parliament residences.
Ms. Matheson talked about the difficulty in getting witnesses, and I've experienced that as well. When we were studying Bill C-21, we also had death threats being given to officials, so members of the civil service, nonpartisan members of the public service who appeared, and the chair of the committee had to warn the Conservative members to tone down the type of the way they were questioning these officials, because it was directly impacting their safety. When Ms. Shanahan read the definition of harassment, it included, cyberbullying, spreading of malicious rumors. Should that not apply to MPs and our behavior as well?
It's a very good question, and again, I think something that the committee and a potential subcommittee would want to think long and hard about. It's that line, I guess, between the genuine need to be as free as possible to express views and play the role of either a government member or an opposition member, versus, to your point, the right to have a healthy work environment for members, their staff, anybody else who sets foot on Parliament Hill. It's a very difficult question.
If you don't, I wanted to talk a little bit more about staff, because it's becoming more difficult as an MP to not only hire staff but retain staff because of the abuse that they're receiving in offices. The phone calls, for example, mostly in the community office, but they also read about what's going on and they see social media. And it's becoming difficult to retain people, understandably, despite services that you offer. It's first of all, they're not. They just shouldn't be subjected to this in any way, shape, or form. Do you want to comment maybe on the retention and hiring difficulties that MPs are facing?
Got about 30 seconds here.
There's a talent war out there, so I would say it's not limited to MPs, but definitely the environment would definitely contribute more if they are seeing it both on social media or in committees or. But I would say at this point I would always encourage to come back and maybe reach out to us just to make sure that there are some preventative measures that are put in place for employees to just ensure that they're feeling safe both mentally and physically. I would just urge to contact us.
Merci. Okay, colleagues, that concludes the first panel for today's portion of our study. I would like to thank Mr. Leblanc, Mr. McDonnell, Mr. Bédard, Mr. Jantz, Ms. Evangelidis for being here with us. Colleagues, that was a productive, efficient, and most importantly, respectful first half of our conversation today. It was very informative and I think serves as a beautiful catalyst for what's to come. So thank you very much for being here. We're going to suspend for 5 minutes to set up our next panel, and we will resume shortly. Je rappelle la réunion à l'ordre.
I'll call the meeting back to order for our second panel.
Today we have with us the Honorable Greg Fergus, Speaker of the House of Commons. Welcome to PROC, Mr. Speaker. Colleagues, as you know, we are here today continuing our conversation on harassment, as we had just undertaken in the past couple of hours. As per the last round of questioning, we will have first round that comprises of 6 minutes to members of each party, and then we will move on to a second round, which will be slightly reduced in time. Colleagues, just a reminder in terms of the protocols around our audio devices, out of respect to our translators, their health and safety, and the hard work that they undertake on our behalf, please make sure that we are placing, when not in use, our earpieces on the stickers. I note that Monsieur Leblanc, Monsieur Bédard, Mr. Jantz, and Ms. Evangelidis are still with us, so welcome back. With that, colleagues, we are going to get right into things. Mr. Speaker, there are 10 minutes available to you for opening remarks. With that, I turn it over to you.
Well, thank you very much, Mr. Chair, and I thank the committee for inviting me to appear today to discuss this important issue of harassment at the House of Commons. You have already heard from House officials on this complex matter, and I understand that they spoke to you in detail about the policies in place in the House of Commons to address issues of workplace harassment relating to employees, as well as harassment issues between members of Parliament. As committee members know, it has been my objective to improve the atmosphere in the House. Decorum is an issue which has been raised with me not only by members, but also by the general public. How members treat each other in our workplace is, of course, of interest to all of us. La Chambre des Communes est une des...
The House of Commons is one of the oldest institutions in our country. Its form of proceedings is even older. However, it must also find ways to balance these deeply rooted traditions with the expectations of modern workplaces. On an individual level, these measures exist to foster work environments where people feel safe and unthreatened. As Speaker, I play an important role in the management of the House of Commons as Chair of the Board of Internal Economy, which is responsible for the administrative and financial affairs of the House. My responsibilities also cover the presiding of parliamentary proceedings. My comments will focus primarily on the latter area.
Harassment measures detailed by officials earlier cover employees who work on Parliament Hill. That includes staff of the House of Commons and staff working for members of Parliament. Employers of these categories of staff are subject in various ways to the provisions of these measures. However, other than the Code of Conduct dealing with sexual harassment between members, there are currently no workplace measures in place to address other forms of harassment that might occur between members of Parliament within the context of proceedings in the House and committees. The House is not unique in this regard, as many other assemblies do not apply internal codes of conduct to their proceedings. While there could be instances of harassment that are physical or sexual in connection to the proceedings in Parliament, generally, the likeliest form of harassment in this context would be through the spoken word, when members are participating in debate in the chamber or in a committee meeting. Comme nous le savons,
as we know, a preeminent immunity enjoyed by members while discharging their parliamentary duties in the House and committees is that of freedom of speech. On April 29, 1977, the Special Committee on Rights and Immunities of Members presented its first report, which can be found at pages 720 to 729 of that day, of the journals of that day. It states that for members, freedom of speech, and I quote, is a fundamental right without which they would be hampered in the performance of their duties. It permits them to speak in the House without inhibition, to refer to any matter or express any opinion as they see fit, to say what they feel needs to be said in furtherance of the national interest and the aspirations of their constituents. End of quote.
The ability to engage in debate in a robust and frequently pointed fashion. This age-old feature of our House, this is an age-old feature of our House, and is the cornerstone of our Westminster-style parliamentary tradition. It ensures that a member has full latitude in pursuing any matter of public interest or of importance to them. As such, this is an immunity that is fundamental to our proceedings. I must emphasize, however, that this does not mean that members have no protections in the chamber or committees from inappropriate comments from other members. Another ancient principle of our tradition are the rights that the House enjoys as a collectivity, which are catalogued in the House of Commons Procedure and Practice, 3rd edition, at pages 119 to 141. Chief among them is, and I quote, the regulation of its own affairs, unquote. This refers to the House's exclusive authority to control, quote, its own debates, agenda, and proceedings as they relate to its legislative and deliberative functions, unquote. Related to this is the House's exclusive right to discipline its members. Through these powers, the House has tools to hold any member accountable for any action that may be viewed as conduct unbecoming and misbehavior, including in the exercise of their individual right to freedom of speech. The House has exercised these powers in the past to address cases of inappropriate behavior by a member. Les préoccupations que suscitent depuis quelque temps les propos non
The ongoing concern over inappropriate parliamentary language in the House, especially that of a personal nature designed to attack, to belittle, or bully, is ultimately a matter of decorum. Part of how decorum is improved in our proceedings is by removing the aspects of our debate that aim to personalize political criticism. As we've seen in the past, making things personal frequently elicits strong counter-reactions, reactions that are not only disorderly to our proceedings, but can genuinely be felt to be harassing when an individual on the receiving end of the personal comments of the critic.
Members' goodwill can be appealed to voluntarily improve the atmosphere in the House. However, stronger measures may be needed on rare occasions. In this respect, if the power to enforce proper decorum rests in my hands, broader disciplinary tools are properly the purview of the House. I would suggest that the House be prepared to use its power to discipline in those rare cases where statements may cross the line, bordering or reaching the threshold of serious misconduct. While the House has effective disciplinary tools and a strong commitment from the chair to make improvements to decorum, it cannot be done without the cooperation of all members. The second point I'd like to address is whether stronger rules are needed to address instances of harassment amongst members. As the committee knows, the standing orders of the House of Commons contains 2 appendices. The first, the Conflict of Interest Code for members of the House of Commons, which deals with obligations of members to avoid conflicts of interest of a pecuniary nature when carrying out their parliamentary functions. The second, the Code of Conduct for Members of the House of Commons, Sexual Harassment Between Members, defines sexual harassment and sets out a dispute resolution mechanism when complaints arise.
However, missing from both these policies are rules that could address the issue of other forms of harassment between members. Some have seen its absence as a gap. I would only caution that any attempt to expand these codes of conduct should be done in a way that respects the privileges that are enjoyed by the House and its members. Before concluding, I would like to address one other issue, namely social media. Members are very aware of, and unfortunately often the target of, vile and sometimes criminal comments made towards them on various platforms. These comments are most often made via cowardly anonymous accounts, making follow-up action by either cyber security or by the police very difficult.
Never to the same degree. There have been instances of members posting comments regarding fellow members on social media that some would qualify as inappropriate or even harassment. While obviously a serious matter, it is not one that the Speaker has jurisdiction over. It is a long-standing practice that the Speaker does not comment on statements made outside of the chamber. I'm grateful to the committee for their attention to this matter. It is important work and it is timely. Those are my thoughts on the issue. I hope my testimony will help the committee in its work in considering this matter. I very much look forward to the recommendations that this committee might be able to offer the House. I remain at your disposal to further assist the committee as it moves forward on this study. Je vous remercie.
I thank all members for their attention, and I look forward to answering any questions you may have. Thank you very much, Speaker.
Ms. Rempel-Garner, it is your floor for 6 minutes.
Thank you, Chair, and thank you, Speaker. Speaker, you're responsible for overseeing the harassment policy for the House of Commons. Is that correct?
That is correct.
Would you characterize a physical altercation between members in the chamber as a potential instance of harassment?
Well, to be clear, that would be more of I should just modify the first sentence. I'm responsible for the sexual harassment between members, as it was listed. If there was a physical altercation, yes, that would be behavior that would be considered unbecoming.
Thank you. On May 18th, 2016, the Prime Minister grabbed late Conservative MP Gord Brown by the arm and then elbowed former NDP MP Ruth Ellen Brosseau in the chest. Ms. Brosseau expressed that she had been injured, and in that moment, you're recorded on the Hansard as saying, you described Ms. Brosseau's complaint as reminiscent of a dive in the 2006 World Cup, and that she was exaggerating. On what basis did you arrive at the finding that Ms. Brosseau was either diving or exaggerating what had happened in the House?
If I recall, my statement on that wasn't in regard to Madame Brosseau's accounting of the incident, but of other folks' accounting of the incident, which was...
Sorry, go ahead.
I'm sorry, go ahead.
So are you saying she experienced it differently than what she had said in the House?
No, I think she experienced it exactly the way she expressed it in the House.
Yet you said it was... I'm just curious at how you arrived that it was a dive.
I was commenting on how other people were characterizing, not what Madame Brosseau had said, but what other people had described it as being.
Well, your exact statement was it happened exactly as the Prime Minister had described it. So I guess that's your statement, and you're now responsible for overseeing the harassment policy. Given that this instance and the numerous instances of partisanship you've been accused of while you've been sitting in your term as chair, do you think that opposition MPs would feel safe or empowered to report instances of any sort of harassment, given that this department comes under your supervision?
They could have complete confidence that issues of harassment, if it's raised, will be given the full and treatment under my office.
See,
and by
I
me
don't think
personally.
so, Speaker. Oftentimes women don't report harassment because men in spaces of power where they have demonstrable past experiences of holding on to that power and protecting those in their circle, that's where justice isn't served. And so my concern with your partisanship is mostly to do with this issue. We are discussing a very serious issue here. This is something that impacts all MPs. And I am not sure that if I reported something to you, that you would treat me fairly, that I wouldn't have my issue twisted for partisan gain because of the repeated instances of partisanship. And that's why I have lost faith in your speakership. So given all of this, do you think that the fact that I have to ask this question or make these statements will prevent MPs or staff members coming forward from reporting instances of harassment because of your track record in this issue?
I don't believe so. I believe that members should feel fully confident in my ability to ensure that they are given every and to the fullest extent of the rules that have been set forward by the House of Commons to bring, when they bring forward serious issues, such as harassment, especially sexual harassment, that it would be treated with the utmost seriousness and to the fullest extent possible.
Yet in the moment when you had an opportunity as a peer in the House of Commons to give a woman space and hear her argument out, your exact words were this: what happened was exactly as the Prime Minister had described it. If I came in and I said, this happened with a Liberal member or a Conservative member, whose side would you take?
I would clearly want to make sure that the process was entirely fair and that your story and that your concerns would be raised and pursued to the fullest possible
How can I have that assurance?
That could happen.
How can I have that assurance
I'm
when you've
offering you
had
that
three clear instances of like being partisan while in the chair? Forget the fact that you were the Prime Minister's parliamentary secretary. Like, I'm saying this out of deep severity. That is, I believe you have lost my confidence because of this issue. You are in charge of the harassment policy, something that is very serious because it governs the workplace safety of everybody here. I just want to end with this. I don't understand why the NDP, given that this happened with one of their colleagues, is still propping you up. I don't get that. But again, I just want to give you, how could you in that moment, in showing a judge of fairness, supposed fairness, how could you arrive that this woman experienced it differently and that the Prime Minister, what basis did you use to make that comment in 2016?
Well, I can tell you that I never questioned Ruth Ann Brousseau's accounting of the situation.
You did. You said, I believe him, not I believe her. And that is what is wrong with every workplace around the world. And yet you demonstrated that in that moment. And deeply disappointing.
We have about 10 seconds left. Mr. Speaker, did you want to
just very quickly, once again, never doubted her accounting, and my characterization of it at the time was due to how
other gaslight me on that right now?
Ms. Rempel-Garner, I think either we have to let the clock run or we have to afford the Speaker the opportunity to respond. Mr. Speaker, did you want to take the last few seconds, or do you feel satisfied with the response?
I would just like to say that, again, just to make sure that the record stands, that my description of that event was an accounting of what other people had described her event, and not how she had put it on.
Okay, thank you very much. Ms. Rominato, the floor is yours for 6 minutes.
Thank you very much, Mr. Chair, and through you, I'd like to thank the Speaker for being here today. So in the previous panel, we had some excellent testimony with respect to the harassment policy that currently does not apply between harassment between two members of Parliament. And we talked a little bit about the difference between having healthy debate in the chamber, bringing forward questions on policy, bringing forward recommendations to improve legislation, and sometimes a lack of civility in the House. and how that can be used outside of the House. So, as you know, in 1977, cameras were allowed into the chamber to allow Canadians to participate in debate and learn more about our democracy, which is incredibly important. But I also know that often when I'm in the chamber, it seems like it's theater. And I remember when I first got here, someone said that to me, question period is the theater. And it's for the clips that are used to then put on social media. You mentioned that anything that comments made outside of the chamber are not the purview of the speaker. But if members of parliament are taking clips from inside the chamber, putting them on their social media, that then generates sometimes unhealthy comments, what would you recommend? Is there anything that this committee could recommend to improve the civility in the House and understanding that the words that we use matter, that there are ramifications for sometimes the words that we use, and that some people out there are using that as a way to intimidate members of Parliament? Could you elaborate a little bit on that?
Through you, Mr. Chair, thank you for the question. It's really important, once again, to note that the Speaker, according to the rules and the long-time tradition of this place, does not have a purview over what happens outside of the House, outside of committees. If, however, members, and this is the reason why I'm presuming that the committee had been struck to take a look at this issue, are free to propose solutions and perhaps could direct members themselves in determining what would be considered behavior that's unbecoming, could direct the Speaker to observe for that, but it has been a tradition that the Speaker doesn't go there for many reasons. And whatever this committee comes up with would have to be tempered, of course, with the long-standing traditions of this House to allow for as much as possible full and free ability to speak to issues. That is fundamental to the roles which we play as members of Parliament, and one that should always be looked at and should be minimized with the greatest of care.
Thank you. So, in terms of decorum in the House, we do have certain standing orders that members need to abide by. We can't question the integrity of a member. All members are honorable and so on. But we've noticed that it's getting harder and harder in the chamber for members to respect that. And we're seeing, especially I guess we're in what we call silly season, where tempers get a little flared in the House and so on. Do you think that we should be making some recommendations in the standing orders to include, for instance, you mentioned that we have the Code of Conduct for Sexual Harassment in the appendix of the standing orders. We also have the Conflict of Interest Code in our appendix of the standing orders. But we do not have harassment between members in the current standing orders. We have free from molestation as a standing order, free from questioning the integrity, but we do not have harassment. Should we be amending the standing orders to include harassment amongst members?
That's going to be up to members. And I'm assuming that this committee is going to be doing that and proposing a report to all members in the House. So it will be up to you to determine, do you want to go beyond the sexual harassment rules that we set out and to consider harassment generally. And to do so, of course, tempered by the importance of allowing members to have as full a possible range of free speech. It could be... I think decorum and civility are really important. I think it is possible for us to have pointed and passionate debates, but one which does so within the confines that is respectful of the traditions of this place. And in fact, what those traditions end up being are traditions that I think that any constitutional democracy would consider appropriate. And so I think it allows us to continue in that best manner. So I'm really interested into what the work that this committee will do, and to the people and the witnesses who you speak to, and the recommendations that you will have.
So on that last point,
Very
because
quickly, Ms. Brown.
because this committee cannot, we can make recommendations, but I believe it's actually the Board of Internal Economy that would actually institute any recommendations. And I understand that the speaker is on the Board of Internal Economy and chairs it. So given that, we cannot, normally we table a committee report in the House and ask the government to respond, but because the government is not responsible for this, how would you suggest that we word any recommendations in our report to the House to make sure that we can get the adequate response?
You, very simply, you would change the, you would make recommendations to the Code of Conduct of Members, and then the board will, if adopted by the House, then, or concurred by the House, then the board will act accordingly.
Thanks, Madam. Sorry? Yeah, very quickly, Mr.
Just
Jansen.
a quick clarification. Again, there's two things. There's the policy that falls under the jurisdiction of the board, and then there's the code, which falls under the jurisdiction of PROC, and then recommended to the House. So again, if the idea is to change the code, that would fall within the jurisdiction of this committee. Could report to the House, and if the House adopts it, then the annex to the standing orders would thereby be changed. If it's changes to the policy, the process would be for this committee to write a letter with suggestions, recommendations to the board.
Thanks very much, Mr. Jans. Madame Gaudreau, à vous pour 6 minutes.
6 minutes. This is something that's very important, what we've just spoken about. Thank you very much, Chair, and I thank the Speaker for being with us this morning as well. I think we know each other well. We've been on PROC together, and I've been on PROC for 5 years, and myself. Things have changed in terms of the free deliberations in the House, but I have to also say that I am fearful of the climate in the House. There's been a great deal of slippage. Every week, I have students visiting me, and I have to do a debriefing with them afterwards because I'm ashamed of what they've seen. And if I were to ask a secret question, are you proud of who we are? I bet you'd answer, no, not at all. So how can we then respect this very relevant and interesting jousting match that we have between the government and the opposition without falling into the trap of harassment? We have seen what type of control we have over our social media. The Sergeant at Arms has said that there are some 800 requests, asks based on social media and what's written in social media. I have to tell you that this is slippage, and it's you know, this is finished. It's got to come to an end. I would like. I can never say this. I'm a Quebecer, but you know, I'm not want to say that I'm proud to be in the House of Commons as a Quebecer. But when I see what is said there and what happens there, even less so. Well, I'm losing my thread here. I, too, want to get to the end of the session to recharge my batteries to be able to rest. So my question. We're going to submit priorities. We will have a committee, maybe even include some members of Parliament on that committee to consider what we submit. But what can we do practically to stop this slide down the slippery slope that we have undertaken in the House of Commons? Thank you very much, Madame Gaudreau. I thank you for your candor, sharing your experience with the young students that come to the House of Commons to see what we do and see us in session. This is something that is of deep concern to me as Speaker. You're not the only one, you know. you're not the only one to wonder about this type of issue, to ask these questions, because I've had discussions with members of all parties about this. Everybody is wondering what to do. As a member of Parliament, you have to make choices. You can have passionate, pointed discussions. You can ask for accountability from the government above others to answer questions that you put, clear questions. And you then create an environment where you debate ideas, but you do not attack the person. As a member of the Bloc Québécois, you know full well that here in Ottawa, ideas are important in Ottawa. It's up to all of us to burnish the debate, to make it better. And I believe we can do so. It helps when there is a greater interaction, greater mingling amongst members, not just formally in our roles, our adversarial role facing each other. It helps to have a meal together. It helps to travel together on a parliamentary association trip, to get to know each other better. It's not something that is specific that you can put your finger on, that you can create regulations about, but it is truly important, and that is the tie that binds in our parliamentary system. Well, thank you for your answer. I can say that there is a power that each of us holds, but we also have the power to proceed with our deliberations. In the Bloc Québécois, respect is important. Freedom of expression is everywhere in our discussions in the Bloc. Never would we have to experience or live through what we have to live through in the House of Commons. I know that well as chair of our caucus. So I think there has to be a 180-degree turn taken here. Something has to be done about behavior, about the rules. Either we respect the standing orders or we don't. That's it. Thank you.
For 6 minutes.
Thank you, Mr. Chair, and thank you, Mr. Speaker, for appearing today. And I just wanted to say that ultimately I reference a point that actually Ms. Rempel-Gardner had brought forward in the previous panel, that it's important for us to not use this really important study to play partisan games. And so I'm glad to see you here within your role as the speaker of this institution. And give us advice in terms of as you see it in your experience. I did want to get to some of the things that you said, however, because it concerns me. I mean, there is this idea, of course, and we are all surrounded by those long-standing traditions, as you talked about it, that history, the incredible responsibility that we have to uphold that to some degree, but also to represent the people who sent us here, of which I am so incredibly proud all the time, but to make the changes that we need to help them to make their lives better. Those changes and this institution then has to evolve with the society that we do represent. So as an institution that is patriarchal, that is colonial, that is that has seen some dark times, as our society has. How do we ensure that we're doing both? How do we find that balance? Because this conversation about harassment hinges on that, I think. And it is about respect. It is about understanding that we are truly all equal. So how do we balance that?
Well, that's a very good question. I mean, we do have some of the most, we have these traditions which long precede even the existence of Canada, which are important traditions. They've withstood the test of time, but we also have to try to make we always have to continually take a look at how can we modernize these institutions to make it more reflective of what Canadians live and work in each day in their own workplaces. But we need to make sure that we always have that balance. It's just not easy. I don't have a quick answer, but I do agree that it would be very useful.
So to me, there's this clean the delineation. Ultimately, though, do we set forward some rules? Do we put our mind to putting forward written down rules, or do we? There was sort of this idea that it seemed like we were getting to a point where this is about almost peer pressure, that we simply don't expect, or we have expectations of other members and they don't cross that line. Is that where we're at, in your opinion, as within your role?
Well, I think we can do both. So I think there is one aspect of it, of course, is that the committee can make recommendations to Parliament about changing the code of conduct of members and set out some guidelines. Not necessarily, you don't want a tax code of you shall not do this, in this kind of situation, but maybe some aspirational aspects as to what we would want members to live up to. And then allow, of course, the Board of Internal Economy to try to operationalize that, and then for members to pursue that. And then the other aspect of it is that, of course, there has to be some notion of peer pressure, I guess, from member to member in terms of what we would expect other members, how we comport ourselves, and how we would expect others to comport themselves.
I think that we do have an obligation to change this institution to be what it needs to be, what we want it to be, to simply, though, elect all kinds of incredible people from different diverse backgrounds and what have you, and to place them within the same old institution, to then make them almost a victim of that and those long-standing potential dark histories is a problem. So are there mechanisms, could we consider what electoral reform would bring to that? Should we consider consensus building in more of an Indigenous tradition of how this place operates? How difficult would that be?
That's a really big question, Ms. Matheson. But 5 seconds. So look, I'll just say it really, really quickly. I have a minute. All right then. Thank you. I would say a couple of things. Let's not completely turn our back. This institution has evolved. It has evolved significantly over the last 157 years. Has it evolved? Does it always match to the times in which they live in? No. There is a lag, but it has evolved, and it has evolved, I think, for reasons that you pointed out, because we're electing more people more women, for example, has made a significant difference on what it would be to be a member of Parliament today for London Fanshawe as opposed to your predecessor, and how she might have felt back in the day. So there has been change. But what we're trying to do here is to take a look, can we go further? And the challenge, and I think the real objective for all of us here is, can you negotiate yourself into a new sweet spot? Can you propose something that respects the traditions, but yet allows for this modernization, which is so necessary? And that's a challenge. I don't think there's going to be an easy solution here.
Thanks very much, Mr. Speaker. I'm used to you giving me the, time is running out. It's nice to return the favor. Mr. Giovanni, it's over to you for 5 minutes.
Thank you, Mr. Chair. Mr. Speaker, so your job is to oversee the parliamentary precinct, to be a referee in the House of Commons, and to oversee the House of Commons harassment policy. When performing these duties, would you agree that it's important to remain neutral?
Of course, I would agree that it's important to remain impartial. I hope all the decisions that I've pronounced in this place would be judged by any fair-minded person as being decisions that could stand the test of time and that were impartial.
So as part of this, you no longer attend the weekly meetings with Liberal MPs, caucus meetings, for example?
Absolutely.
With regard to the harassment policy, would you agree with me that it's important for the accuser and the accused to have confidence that they will be treated fairly according to the harassment policy, regardless of what party that they're a member of?
I would hope that they would feel that the process that was set up was one which allows them to both be able to feel free to express themselves, to raise the issues, and for it to be properly disputed.
So today there's an ongoing debate about your partisan actions and whether you should remain a speaker. There'll be a vote later today on that. The story for the fundraising event and the highly partisan language used was that it went out in error and that it was a commonly used template. Have you been given assurances from the Liberal Party that this is in fact the story and that this template was widely used by other MPs?
So you'll forgive me, Mr. Giovanni, but this is a matter which is before the House. It wouldn't be appropriate for me to comment on it right now before the House pronounces on this.
Okay, so if you haven't been given that assurance, or at least we can't confirm right now that you have been, do you think that MPs who want confidence and trust in the harassment policy should be concerned about the judgment of the Liberal Party in using the office of the Speaker for partisan purposes?
Again, Mr. Giovanni, you're putting me in a very uncomfortable situation. I would love to be able to comment on this issue. It just wouldn't be appropriate for me to do so when this matter is before the House.
Okay. Well, why don't we zoom out then? We can zoom out to make you a little more comfortable from what we're talking about in the House today. Just generally speaking, do you have a policy on how to avoid this sort of partisanship from bleeding into your activities as the Speaker of the House?
As was discussed before this committee, and as was reported on before this committee back in December, and it was reported to the House at the end of January, there are a whole bunch of recommendations on that front, and there are general guidelines which are provided for in the rules of procedure. But as was, I believe, if you were to take a look at the committee report, you will discover that there was a conclusion that these guidelines were vague at best.
I would say it is unfortunate that when we're discussing an important policy like this one, that the discussion is sort of marred by your inability to address some of these concerns. And I would just recall that following your address to the Ontario Liberal Party Convention, which also raised concerns about partisanship, you said it was an error and apologized. Following the most recent partisan intervention, you said it was an error and it won't happen again. Before MPs vote tonight on if you should remain chair, why should we believe you?
It's a long-standing tradition in this House, of course, that when members withdraw or apologize for a comment, that the member is taken at his or her word.
I'd like to see the remainder of my time to my colleague.
Okay, Monsieur Berthoud.
Merci beaucoup, Monsieur Fergus. Merci de votre présence. Je vous écoute depuis le début.
Thank you, Speaker, for being here. I've listened carefully to you since the beginning of the meeting. You've spoken about decorum, about the intent of members when they make remarks. You are at the very heart of another question of privilege concerning your partisanship. Partisanship in the House of Commons as well as outside of the House of Commons. You have a somewhat elastic idea of what partisanship seems to mean. You are supposed to be the arbiter of debate. You adjudicate the debate. And you have to look to the intentions of the members in the House. But you find yourself faced with issues that have never before surfaced for any Speaker of the House. Why do you think that you should maintain the speakership? Well, as I said to your colleague from Durham, I cannot speak to this matter that is before the House. It is before the House right now. Well, when do you think it's time to resign? Well, sir, that is an issue, a matter that is before the House, but your personal perception. No, Mr. Berthold. I would like to give you a few more minutes, but there is no more time for you at this time. Madame Fortier, you have the floor for 5 minutes. Thank you, Chair. And going back to the matter that we are studying today, I thank the speaker for being here today. With your experience, I'm sure that you can help us better understand the issue before us. Here is my question. Behavior in the House that goes beyond debate, that transmits a notion of harassment. Would you be able to give us some answers about any instances of that? That is an excellent question, Madame Fortier. I can say to you that as a member since 2015 and as speaker, I can say this. There are times when I wonder myself, does this moment go beyond what is acceptable? I can say this. I'm always concerned by tradition and by the standing orders of the House. They're very important. But I do ask myself this question. The behavior between members of Parliament, of any party, of all parties, is that behavior acceptable, and would it be acceptable in any other work environment? I would think the answer is no. However, this isn't like just any other work environment. We are debating ideas that involve confrontation. They're conflicting ideas sometimes, pointed questions, unexpected things, but is that acceptable? Well, as Speaker, have you seen anything in the House, or have you had any experience as Speaker in the chair where you've seen harassment demonstrated by other members? Or I'm just trying to keep this within the House itself. I can't speak directly in answering your question. I can't. And each and every day I have to evaluate the matter. For me, I look at the standing orders of the House. I look at is it that as the framework, and is the behavior there, or what is being said, does that fit into the framework? Would I or anybody else occupying the chair feel free to request a change in behavior from the Member of Parliament? Well, I don't have much time left. I know that there is much that is before us. So the question that my Bloc colleague asked is a question that is preventive in nature. Do you think that there are certain things that can be done to prevent the situations we find ourselves in? Well, it's social media. That goes well beyond what the chair can do. But if members of Parliament were to decide to give that power to the chair, well, otherwise, the Speaker cannot be a judge and jury on everything that occurs outside of the House itself. As to your initial question, do I have suggestions? If I were in your shoes, if I were in your place, I think that it would be more useful to have a code of behavior rather than a volume of all the things that are not to be done, that should not be done. it would be too complicated, much too complicated. Thank you very much.
Merci. Madame Gaudreau, à vous pour
2.5 minutes, Madame Gaudreau. Well, thank you very much, Chair. As we have heard, and given what we've heard, is it possible to know what we can draw as a conclusion from this meeting? What can be done for members of Parliament and their behavior? What can lead us to dream of a change in behavior in the House of Commons? Well, today, I think that all the pieces are there. The pieces of the puzzle are there, and that should allow us to finish the puzzle. We all have to be disciplined. Self-discipline is something that each and every one of us has to demonstrate. Ms. Matheson, in her question, was coming to that point. I think that there is a need to modernize our code. And in that modernization, we have to bear in mind that we don't want to throw the baby out with the bathwater. We can't ignore the traditions of this place. Tradition has survived for very good reasons. I think that the work may not be absolutely perfect, the first draft of that work, but we keep at it. Thank you very much, Mr. Speaker. You have 40 seconds or 30 seconds left. Do you want to use them? I am done.
the beneficiary of an extra 30 seconds. So 3 minutes to you.
Music to my ears. Just to build off of that, where we were going before, has there ever been any look? Often, and thankfully, the government uses a GBA plus lens to look at budgets, and within this institution, has that ever been done for Parliament, for that code of conduct, for standing orders, for the things that govern us and each other?
That's a very good question. I'm the new kid on the block, so I'm going to ask my clerk or perhaps Ms. Evangelidis if we could respond to this question.
And certainly not for the standing orders and the like. I don't know if we do in terms of some of the policies that are developed.
No, we don't. There is a best practice, of course, from a policy perspective. Usually it's to review things within 3 to 5 years, I would say. So that is something that you might want to consider as you move forward. The current code has been reviewed in 2018 and has not yet. So.
Okay. The other question I had, Mr. Speaker, you're responsible for all of the workers who serve this institution overall. Have you heard, or has there been any concerns voiced to you from them as to the impact that are what we are seeing within the chamber, within committee overall, the violence, the harassment, and so on upon the workers who serve with such incredible pride this institution? Is there a mechanism to have that either, actually?
Well, I've been very fortunate in the time that I've been in the chair that I've taken effort to try to meet all of our 2,600 employees, to meet with them, to chat with them, to take time to learn more about their jobs and what they think of how we can improve. And we have regular processes, and I'm very pleased that the House has also set up formal processes for us to do that. Mr. Chair, I hope I'm not going over too much of the time, but I've heard members of the employees here love to work here. They're proud to work here. And I've heard concerns that they've expressed about the nature of the debate. I don't know if they can define exactly what's going on, but I think everybody feels that it might be going a little bit too far sometimes.
Thank you.
Thank you very much. With that concludes our last panel today. Mr. Speaker, thank you very much for availing yourself to the committee here today on this important study. Again, thank you to those other witnesses who have joined. Colleagues, we're going to suspend for 1 minute, and then we're going right into committee business to deal with a few other matters. And we're going to try to get through that quickly so that folks can prepare for question period. So we're suspended for about a minute. We are back in our meeting here. If I could ask everyone to take their seats, please. See you, Mr. Cooper, just 1 sec. So, colleagues, I received, as you did, a letter a few days ago requesting an emergency meeting from more than 4 members of 2 parties, which means that the committee must, according to standing orders, grant permission of that meeting. My understanding is that there have been productive negotiations between the parties with the intention of addressing the nature of that emergency meeting. Our hope collectively is that we will be able to work through the nature of the substance of why it was that meeting was called in the next few minutes. If we can't, rest assured, colleagues, the 1064, which is the standing order we referred to for an emergency meeting, will be honored, and we will come back later this afternoon to address and continue should we not get there. But the goal of this exercise right now was to try to save us all from having to come back later this afternoon while still satisfying the nature of the emergency meeting. With that, Mr. Cooper, I recognize that you would like the floor, and I pass it to you.
Thank you very much, Mr. Chair. I will move the motion that has been put on notice, and I'm going to read it into the record, and then I will make some brief remarks. The motion is as follows. That further to the Globe and Mail report of May 23rd, 2024, which revealed that the Liberal cabinet is withholding an undisclosed number of documents requested by the Commissioner of the Public Inquiry into Foreign Interference in Federal Electoral Processes and Democratic Institutions, and that nearly 10% of documents provided to the Commission by the Cabinet contain redactions, and in relation to its study of foreign election interference, the Committee, A, pursuant to Standing Order 108-3C4, report to the House that, in its opinion, the Cabinet should provide to the Commissioner of the Public Inquiry into Foreign Interference in Federal Electoral Processes and Democratic Institutions all documents requested by the Commissioner without redaction. B, invite the following witnesses to appear. 1, the Honorable Dominic LeBlanc, Minister of Public Safety, Democratic Institutions, and Intergovernmental Affairs for 2 hours. 2, the appropriate representatives from the Privy Council office for 1 hour. 3, the appropriate representatives from the Foreign Interference Commission for 1 hour. 4, Dan Stanton, former manager at the Canadian Security and Intelligence Service for 1 hour. And C, after considering this witness testimony, report its findings on this matter to the House. And so that is the motion that has been put on the table. Mr. Chair, the cover-up continues. After the Prime Minister got caught turning a blind eye to Beijing's interference in our elections, the Prime Minister for months fought tooth and nail against holding a public inquiry. He went so far as to appoint a long-standing family friend as a fake rapporteur to produce a whitewash report to shield him from accountability for failing to act on multiple briefings from CSIS and the Security and Intelligence Establishment about Beijing's interference, including in the 2019 and 2021 elections, because such interference benefited the Liberal Party and the Prime Minister was prepared to turn a blind eye to it. He did turn a blind eye to it and covered it up until he got caught and then appointed Mr. Johnson. Now, when the findings of the Prime Minister's fake rapporteur did not hold up to scrutiny, the Prime Minister finally, after months of calls from Conservatives, succumbed and established a national inquiry, and Madam Justice Hogg was appointed as the commissioner of that inquiry. And at the time of the appointment of Madam Justice Hogg, Minister LeBlanc reassured that the government would cooperate with the inquiry. Minister LeBlanc was quoted as saying, quote, "Justice Hogg will have full access to all relevant cabinet documents as well as all other information she deems relevant for the purposes of her inquiry," end of quote. Well, Mr. Chair, that has turned out not to be true. Minister LeBlanc said that the government would fully cooperate, that it would turn over all relevant documents to Madam Justice Hogg, but we now find out that that hasn't happened. In a report of May 23rd, 2024 in the Globe and Mail, entitled "Trudeau Cabinet Withholding Documents on Foreign Interference from Inquiry," a spokesperson for the Prime Minister's Department, the PCO, acknowledges that 10% of cabinet documents turned over to the commissioner have been redacted, and that there are a further undisclosed number of cabinet documents that have not been turned over at all. And it is evident that these are documents that Madam Justice Hogg has requested, and it's evident based upon the footnote in her first report, in which there is mention of ongoing discussions about documents that Madam Justice Hogg has requested that the Prime Minister's Department has not turned over. Madam Justice Hogg is to fulfill her mandate. It is important that she receive all of the documents that she has requested. And I will remind members of the committee through you, Mr. Chair, that part of the mandate of Madam Justice Hogg is to look at what the Prime Minister, what the Cabinet knew when they learned of it, and the actions or inaction that they took respecting Beijing's interference in our democracy. And in order to scrutinize that and evaluate that and report on that, as is the mandate of Madam Justice Hogue, it is important for her to know what information the Cabinet had. Not parts of the information, but all of the information. And what decisions stemmed from the information that was before the Prime Minister and the Cabinet, information that is being withheld from Madam Justice Hogue. In short, contrary to what has turned out to be the false reassurance of Minister LeBlanc that the government would cooperate with the Commission, what we have is a continuation of the cover-up, of withholding now documents to obstruct the work of Commissioner Hogue. This is completely unacceptable, and it is why we have brought forward the 1064 letter and have put forward this motion to get to the bottom of this obstruction. It is imperative that we hear from Minister LeBlanc and we hear from the Prime Minister's department, and we hear from the representative from the inquiry itself, because it is important that the obstruction end and that all documents relevant and that are requested by Madam Justice Hogue are in fact turned over to her. And I hope that this committee can reach agreement in moving forward so that we can commence such hearings.
Thanks very much, Mr. Cooper. So we will begin debate on the motion that you've moved. If there are speakers, there are. Ms. Romanado.
Let me just put that on the right plate. Thank you very much, Mr. Chair. And I actually had a conversation with Mr. Cooper, and I thank him for bringing forward the motion. And we actually have an amendment that I will circulate to the committee. I will read out what the amendment is to Mr. Cooper's motion. So it would be removing Part A. With respect to Section B, Section B1, we keep the Honorable Dominic LeBlanc, Minister of Public Safety, Democratic Institutions and Intergovernmental Affairs, and add with Nathalie Drouin, Deputy Clerk of the Privy Council and National Security and Intelligence Advisor to the Prime Minister for 1 hour. Remove C. Remove D, and a new C would be after considering this witness testimony, report its findings on this matter to the House, and pursuant to Standing Order 109, the committee requests a government response. So I will send that to the clerk right now so that he could forward it along. And the rationale behind that is obviously with respect to the appropriate representative from the Foreign Interference Commission, because the Commission is actually sitting right now and it is ongoing. I don't think it's appropriate for the person to come and testify. And obviously we would like to have the government's response to this. So that's why we're including that as well in that. Now with respect to A, obviously can't agree with that, but I'm amenable to some feedback from colleagues on that. So you should be receiving that momentarily, and hope we can maybe get somewhere so that we can settle this today and start that study. Thank you.
Mr. Calkins, over to you. Ms. Matheson.
I'm not surprised, but I'm disappointed that a well-thought-out, well-articulated, well-crafted motion by my colleague, Mr. Cooper, could not simply be accepted by the committee because on the face of it, it looks completely reasonable. And the arguments made by Mr. Cooper, I think, are valid. The notion was made by so many members around this committee that we couldn't trust the parliamentary law clerk to go through unredacted documents and make a determination as to what documents could be received by this committee when we were studying the foreign interference matter, both in the context of the privilege motion for Mr. Chong and writ large the foreign interference election study that was happening at that time. So here we are again. The notion would have been that, and the argument was made that this committee is too partisan, this place is too partisan, So we need a public inquiry, even though that public inquiry was actually initially rejected ad nauseum until it became so obvious through whistleblowers that this needed to happen. And the argument was made that, well, we can't trust the parliamentary law clerk, we can't trust this committee, we can't trust anybody but a commissioner, in this case Justice Hogue, and she has, to my knowledge, every security clearance that she needs to see all of these documents, and yet the government still doesn't trust the Madam Justice that they have actually selected, that we have agreed to lead this commission. There is no, this government does not trust. And one can only be left with the inescapable conclusion that the government has something to hide. They don't trust the parliamentary law clerk, who would have, in my opinion, far greater experience in dealing with what parliamentarians could or couldn't see, or what the public should or shouldn't see. But now this has been offshored to the commission, and the same blocking of this information is evident by the proposed amendment to my colleague's motion. And I don't know why my colleagues would presume to know whether or not representatives from the Foreign Interference Commission shouldn't come here. We're not compelling them to come here, we're simply saying they should be invited. I would imagine that somebody from the Commission, Madame Hogue, or her representative, would be mature enough to decide whether or not it's in the Commission's interest to come to the committee on this particular issue. But we're not even going to grant Madame Hogue that opportunity, or her representative that opportunity, based on the amendment from the Liberals in this case. And we believe that Mr. Stanton would have valuable insights to provide this committee about what information the Commission would need in order to fulfill the second mandate of the terms of reference that Madame Hogue has, which is to issue a final report by the end of this year. Time is of the essence on this particular issue, because this House will be adjourning for summer in a matter of weeks. And these are 4 witnesses. It's a couple of committee meetings at most. It's committee meetings that our chair has aptly shown us that he's able to get extra time and resources for, with all of the other workload that we have. And I think we should reject this amendment by Ms. Romanato and proceed with the motion in its original form put forward by Mr. Cooper. There is nothing unreasonable about that motion, and we now find ourselves in this debate again. Thank you, Mr. Chair.
Okay, colleagues, I'm seeing that there are some discussions which I'm led to believe are productive and may get us to our ultimate objective. I'm going to suspend very briefly so that these conversations can take place more seamlessly, and I hope when we come back we'll at least have some direction as to whether we're going to vote on the matter or whether we're going to have to move into the afternoon. So we're suspended for a very brief moment. So here's where we're at. The time has really run out for us to be able to negotiate the proposed amendment any further. So we have not satisfied the spirit of the emergency meeting that has been called. So what I'm going to do is I'm going to adjourn. I'm going to adjourn. Well, I understood there was some different direction from the clerk. Give me 1 second, okay? Okay, colleagues, so just for clarity, there are some logistics on the back end of the committee that make it a little bit more complicated if we suspend. But I want to reassure committee members that if we adjourn, which we are going to do in a moment, that we will still have the emergency meeting, the 1064. We have the resources allocated for that meeting later this afternoon. Now, on that note, we are expecting a series of votes this afternoon. So we do have assurances that we still have the resources even if those votes run long, because the chances of us coming at 3:30 to meet to honor the 1064 are very unlikely given those votes. So once the votes are complete, whether that's at 5:30 or whether that's at 4, maybe they get applied, who knows. At that point, we will return here and we will pick up where we left off, which would be to resume, and Ms. Matheson is first on that speaking list, and it would be for us to resume debate on the amendment that has been put forward to Mr. Cooper's motion by Ms. Romanato. Okay? Are there questions, colleagues? I realize that was a lot. I want to make sure everyone is very confident in the fact that the emergency meeting is being honored, the resources are there. In a worst case scenario, should we not have the ability to deal with the 1064 this afternoon for whatever reason, I have also secured resources for tomorrow, okay? I know that's not what we want, Madame Gaudreau, but we do have to honor the standing order that it's a maximum of 5 days. So all I'm saying is that, heaven forbid, something happen, tomorrow is available for resources to honor our responsibility to hold the 1064. Good? Yeah. Colleagues, I'm going to adjourn, and we are going to meet back up at the earliest possibility after question period and after votes today. Okay? Meeting is adjourned.